For lunch.
Sir, step away from the car. You've been standing out here too
I'm
long.
standing by my own vehicle, trying to go home.
This doesn't look like a car that you would have. Let me see some ID
You
first.
don't have any legal reason to ask for that.
Put your hands behind your back now.
What you're going to do is read this. My wallet.
The body cam footage that opened this incident would later become the single most important piece of evidence in the entire case. But at first glance, it didn't look like much. Just a young officer stepping out of his patrol SUV in a bright parking lot, the camera shaking in rhythm with his footsteps. Nothing dramatic, nothing chaotic, nothing that suggested a career-ending mistake was about to unfold. Yet anyone familiar with body cam footage knows that the most catastrophic moments rarely announce themselves. They begin quietly, too quietly. A shaky frame, an unremarkable setting, a simple conversation that should have lasted 20 seconds and ended with the officer walking away. That's all this should have been. A routine moment, barely worth remembering. But routine is exactly where bias hides best, and where poor judgment does the most damage. The footage shows the officer, Dylan Mercer, 23 years old, thin build, a fresh academy graduate, walking with a tension that didn't fit the scene. His vest straps creak softly with each movement. His breathing, slightly tight, fed into the body cam microphone. There was no call for service, no complainant waiting, no report of suspicious activity. He was alone in the lot on what should have been an uneventful patrol. Traffic hummed in the background. A shopping cart rattled somewhere near the storefronts, the kind of ambient noise that fills every suburban parking lot in America. Then the camera tilted slightly as Mercer zeroed in on the man standing beside the dark sedan. A black male in his mid-40s, calm posture, keys in hand, wearing a black hoodie and jeans, standing beside a car he clearly possessed, unlocked, clean, parked neatly except for one tire crossing a faded yellow line. Nothing about this man matched criminal behavior. He wasn't hiding anything. He wasn't trying to leave hurriedly. He wasn't doing anything except preparing to drive home after what would turn out to be a brutally long day. But Mercer's body language shifted the moment he saw him. His shoulders tightened, his stride changed. His left hand drifted too close to his duty belt, not grabbing anything, but hovering, the way rookies often do when they feel insecure but want to look authoritative. It is a posture that experienced officers learn to suppress. Rookies, however, wear it openly like a badge they haven't earned. When Mercer stopped a few feet from the man, the audio captured the edge in his voice immediately. "Sir, step away from the car. You've been standing out here too long." Not a greeting, not a question, a command. The narration of events would later emphasize that this line, this very first line, showed everything wrong with Mercer's judgment. There was no reasonable suspicion, no lawful basis for detaining anyone. Everything that followed was built upon a foundation of nothing, and stories built on nothing tend to collapse catastrophically. The man beside the car, later identified as Judge Anthony Ward, a state-level judicial officer with 15 years on the bench, responded calmly. "I'm standing by my own vehicle, trying to go home." His tone wasn't defensive. He sounded tired more than anything. He'd likely repeated some version of that sentence thousands of times when leaving work. "I'm just trying to go home." But Mercer didn't hear the exhaustion. He heard defiance. He heard noncompliance where none existed. "This doesn't look like a car you should be driving," Mercer said. "Let me see some ID." Later analysis would describe this moment as the precise second the stop became illegal. The officer was making assumptions not based on conduct, but on appearance. The car was too nice. The man was too black. The hoodie is too casual. The setting is too mundane to justify scrutiny. It was the kind of subconscious bias that departments claim to train out of their officers but rarely do. "You don't have any legal reason to ask for that," Judge Ward replied. He wasn't wrong, and he wasn't rude. He simply stated a constitutional fact. But rookies like Mercer often interpret facts as challenges, and challenges as threats. His next line reflected exactly that. "Refusing now, that's obstruction. Don't make this difficult." There was no obstruction. You cannot obstruct an unlawful demand. But the law didn't matter to Mercer at that moment. What mattered was authority, his authority, and the fear of losing control. The body cam picked up a slight quiver in his breathing as he said the words. Even if he didn't consciously feel intimidated, his body gave him away. Then came the line that shifted everything. The judge looked Mercer directly in the eye, lifted his wallet toward the camera, and said, "What you're going to do is read this, my wallet." The leather flap opened with a soft snap. Inside was a polished judicial badge and a state-issued ID card bearing his name and title. Unlike police badges, judicial badges are unmistakable. They have a weight to them, not just physically, but symbolically. When a judge shows identification, they aren't showing status. They're showing jurisdiction. They're showing the Constitution itself. Mercer froze, not dramatically, not visibly to the untrained eye, but the body cam caught the hesitation. Half a breath, half a heartbeat. A flicker of panic crossed his posture before he forced it back down. Hold on. That's judicial credentials? From that point forward, the nature of the encounter changed completely. The footage ends for Section 1, but the story only begins here. Judge Ward had been awake for nearly 19 hours before Mercer stopped him. He had been reviewing a complex appellate decision, revising legal language, and ensuring the opinion would withstand scrutiny. His mind wasn't on confrontation. It was on going home, resting, and preparing for the next day. But instead, he was now facing an officer who had unlawfully detained him out of bias and inexperience. And unlike most people subjected to such treatment, Judge Ward had the legal expertise to identify every violation as it unfolded. This was not just a bad stop. It was a constitutional disaster, and it was fully recorded. Moments like this become textbooks. Moments like this become lawsuits. Moments like this reshape police departments. But the viewers watching this story unfold have one simple question first. Where are you watching from tonight? Stories like this matter. Subscribe if you want more cases where the truth speaks louder than the badge. Because in this case, the truth had only just begun to surface. When the body cam footage ends in the parking lot, the narrative does not pause, and the consequences do not wait. The moment Officer Dylan Mercer realizes he has been speaking to a sitting state judge marks the exact point where everything in his future begins to tilt sharply downward. The drive from the shopping center parking lot to the precinct is short, but inside that patrol SUV, the atmosphere changes in a way the camera can't fully capture. The radio chatter continues faintly in the background, but Mercer hears none of it. His thoughts drown out everything. His hands stay rigid on the steering wheel, knuckles pale, breathing shallow and uneven. He does not bother making conversation. The judge does not speak either. Ward sits in the passenger seat with an expression that is not angry, not heated, just tired. Tired in a way that comes from seeing the same constitutional mistake repeated too many times in too many years by officers trained to enforce laws they barely understood. Nothing dramatic happens on that drive. Sometimes the most severe consequences begin with the quietest tension. When they arrive at the station, the soundscape shifts instantly. Fluorescent lights buzz overhead. A metal door clanks shut behind them. A printer hums from behind the front desk. The atmosphere inside a police station is always thick with expectation and fatigue. But in that moment, the room becomes unusually still as the officers nearby look up from their tasks. They see a rookie enter with a man who does not look like a typical detainee. They see the wallet still in the judge's hand. They read the expression on Mercer's face. Experienced officers do not need narration to understand the situation. A mistake has been made, and it is big. The desk sergeant, a heavy-set older man named Rourke with more years on the force than Mercer has been alive, immediately recognizes trouble. He stands straighter, sets down his pen, and speaks in a tone far more formal than he ever uses at intake. "Sir, how can I help you?" Ward does not raise his voice. He simply places the judicial credential on the desk. The room shifts. Chairs stop screeching. Conversations drop off. The badge on the counter weighs more than metal. Everyone senses it. Rourke does not waste time, pretending nothing serious has happened. "Judge, let's go somewhere private." He turns to Mercer with the kind of stare that communicates decades of leadership. You have no idea how deeply you've stepped into it. Ward follows him into a small interview room with dull beige walls and a camera blinking red in the corner. He sits with quiet composure, hands folded, the portrait of a man who understands procedure more intimately than anyone in the building. Rourke tries to begin in a way that would normally de-escalate an upset civilian. "Judge, I want to apologize for any misunderstanding out there." But Ward raises one hand slightly, stopping him without force, just precision. "Sergeant, I don't need an apology. I need accuracy." His voice is measured and calm, his tone the same one he uses on the bench. Controlled, authoritative, immune to deflection. "I want to know how your officer justified detaining me in a private parking lot with no criminal suspicion." The question is simple. The answer is no. Rourke calls Mercer into the room like a witness brought before a tribunal. The rookie steps inside slowly, unsure of where to stand, unsure of where to look. His uniform feels heavier than before. His boots squeak slightly on the worn tile. He does not sit. He barely breathes. "Well, officer?" Rourke asks, voice stripped of anything soft. "Explain." Mercer tries to speak, but his throat tightens. He forces out a few words. "I saw him near the car, and I thought—" He stops. His mouth opens, but no sound comes out. The judge watches him patiently, not with pity, but with expectation. Mercer tries again. "I thought the car didn't match the person." There it is, not eloquent, not defensive, just raw, unfiltered bias spoken aloud in its most amateur form. Rourke closes his eyes and rubs his forehead. Ward does not gloat, does not smirk. He simply takes the admission and turns it into clarity. "You mean you assumed I didn't belong to the vehicle?" It is not a question. Mercer doesn't deny it, because denial would be pointless. Everyone in the room heard the truth, and the truth is enough. Rourke tells Mercer to leave. The door closes behind him with a hollow thud. Ward and Rourke sit across from each other at the bolted metal table, both men aware that the next minutes will determine the trajectory of an entire officer's career, and possibly the department's reputation. "Judge," Rourke says quietly, "I won't sugarcoat this. This is bad." "It's unconstitutional," Ward replies. "And that too," Rourke agrees. He asks Ward what he wants to do next, but the judge does not hesitate. "I'm filing a complaint today. Not tomorrow, not next week, today." Immediate action is the only responsible route for him, not out of emotion, but out of duty. Rourke does not argue. He nods, accepting the inevitability. Some officers fight accountability, some supervisors enable them, but even Rourke knows there is no room to maneuver here. The body cam footage already seals the narrative. Any resistance would simply deepen the damage. Meanwhile, Mercer sits alone in a separate room. It is not a holding cell, but it feels like one. He stares at the wall, replaying every second of the encounter. He sees the hoodie, the car, the badge, the look on the sergeant's face, the exhaustion in the judge's voice. His mind loops through each frame like a restless projector. He tries to rebuild the moment in his head with alternate decisions. He could have greeted him normally. He could have walked away. He could have asked a non-accusatory question. He could have, at any step, chosen to apply the constitutional training he skimmed through in the academy. But intention does not erase action, and ignorance does not undo violation. When internal affairs arrives, summoned much earlier than usual due to the severity of the situation, the tone in the precinct changes again. IA investigators are not feared because they are cruel. They are feared because they are thorough. They examine procedure, policy, judgment, and conduct with surgical coldness. And when they interview Mercer, his shaky recollections serve only to solidify the complaint against him. They ask him to articulate what criminal behavior he observed. He cannot. They ask him what reasonable suspicion he had. He cannot answer. They ask him why he felt the man did not match the car. He tries to dance around it, but the answer is already recorded in his own earlier words. They ask him whether he understands what a consensual encounter is versus a detention. His understanding crumbles under questioning. Every answer he gives tightens the noose he placed around himself the moment he initiated an unlawful stop. Judge Ward remains professional throughout the process. He does not insult Mercer. He does not embellish. His statements are factual, precise, and devastatingly clean. He recounts what happened word for word, including the tone, posture, and escalation. His composure only strengthens the case. A panicked person can be dismissed as emotional. A calm judge delivering legal analysis as if from the bench, irrefutable. By mid-afternoon, Ward finalizes his written complaint. IA uploads the body cam footage into their evidence system. Rourke signs off on a preliminary misconduct report. The department's legal advisor is notified, and an internal memo circulates with a subject line that sends a chill through every ranking officer. Immediate review required. Potential constitutional violation involving judicial officer. This is the moment where the story escapes the confines of one rookie's mistake and becomes an institutional issue. Departments can absorb minor grievances. They cannot absorb proven racial profiling against a sitting judge caught on camera with no ambiguity. Behind closed doors, the command staff begins calculating. They know civil litigation is coming. They know headlines are coming. They know the Attorney General's office will see this as a blueprint for broader oversight. Every question becomes a liability question. What was Mercer's training record? Were there previous complaints? Did supervisors ignore warning signs? Were there staffing shortcuts? And then they look. Mercer had 3 complaints in 7 months. None were formally sustained. The complaints were resolved verbally, a phrase that in many departments means ignored because we were understaffed. Training notes mention impulsiveness. A field training officer flagged poor threat assessment. A supervisor wrote that Mercer tended to escalate rather than communicate. All these red flags existed. None were addressed. Judge Ward knows none of this yet, but he will. And when he learns it, the situation will escalate even further. Late in the evening, as the station quiets down and most officers head home, Ward leaves the building with a calmness that unsettles everyone watching. Because calmness is not forgiveness. Calmness is preparation. He does not slam the door. He does not raise his voice. He simply nods to Rourke and exits through the front. As the door closes, Mercer is still sitting in the interview room, staring at the wall, the weight of the day suffocating him. Outside, the city moves on as normal. Cars pass, streetlights flick on. Pedestrians walk by unaware that inside the station behind them, an event has occurred that will reshape careers, policies, and reputations. For most people, it was just another Wednesday. For the department, it was the beginning of a storm. Within hours, emails begin circulating. Attorneys start drafting. Administrators start preparing statements. Mercer is placed on restricted duty pending investigation. The union sends a representative. The judge's complaint enters official records, and a department that tries to bury warning signs is forced into the light. The internal investigation did not take days to begin. It began the moment Judge Anthony Ward stepped out of the station. Long before the official documents were filed, long before the statements were collected, long before the footage reached public eyes, the department already sensed the gravity of what had unfolded. Some events move predictably, slow, bureaucratic, procedural, while others detonate instantly, sending shockwaves through every level of the organization. This incident belonged unmistakably to the latter. The first tremor hit early the following morning, when the Internal Affairs Division began its formal interviews. Officer Mercer sat across from 2 IA investigators in a small, dimly lit room designed to unsettle. The ceiling vent rattled softly. The table's metal legs scraped faintly every time someone shifted their weight. I did not raise their voices. They didn't have to. Their silence was more effective than any confrontation. Their questions moved in one direction only, toward the truth Mercer could not avoid. Officer Mercer, describe your reasoning when you initiated the encounter, one investigator asked. Mercer swallowed, fingers twitching against the table. I saw him standing near the vehicle. It looked suspicious. The investigator did not even blink. What specific behavior suggested criminal activity? Mercer hesitated. He was just standing there. I don't know. It seemed off. You understand that standing near your own vehicle is not a crime in this state? Yes, Mercer muttered. Then what was the reasonable suspicion? Again, silence. The kind that filled the room like steam from a boiling pot. Mercer's face tightened. He tried to rebuild his thoughts into something defendable, but every attempt collapsed before it reached his lips. The investigators pressed further. Why did you say the car didn't look like something he should be driving? Mercer's shoulders drooped. It came out wrong. I didn't mean, but you said it. And it was captured on a body cam. He looked down at his hands. I wasn't thinking. That line, I wasn't thinking, became the recurring theme in the interview, repeated in different forms, all revealing the same truth. The officer who detained a judge had no legal foundation for doing so. No reasonable suspicion, no probable cause. Nothing but assumptions formed in an inexperienced mind. The investigators moved to protocol. Did you consider making the encounter consensual? Mercer hesitated. No. Why not? I don't know. What legal grounds did you have to demand identification? Mercer's silence again became its own confession. IA interviews are designed to extract clarity. And clarity is unforgiving. Every time Mercer tried to defend his decisions, the investigators countered with constitutional realities, policy guidelines, and training standards that he failed to meet. By the time the interview ended, everything was clear. This was not a misunderstanding. This was a textbook violation of the Fourth Amendment, compounded by racial profiling, all recorded from the moment Mercer set foot in that parking lot. While IA interrogated Mercer, Judge Ward was already preparing his next steps. He had filed his initial complaint, but now he moved strategically, contacting legal advisors and informing the appropriate judicial oversight committees. Not as revenge, not as retaliation, but because the integrity of the system demanded it. A judge cannot ignore constitutional violations, especially ones committed against him. To do so would be a dereliction of duty. The second tremor hit at the administrative briefing held later that morning. High-ranking members of the department gathered around a long conference table, each holding printed summaries of the preliminary findings. The police chief arrived later than usual, her face set in the kind of hardened neutrality used by leaders who know the situation is about to spiral, far beyond internal control. She opened the meeting without ceremonial introductions. What we're dealing with is serious. A judge was detained unlawfully. The interaction was recorded, and there may be evidence of racial bias. The room remained silent except for the hum of fluorescent lights overhead. One deputy chief cleared his throat. "Is the footage ambiguous?" "No," the chief said sharply. "There is nothing ambiguous about any of it." The legal advisor tapped a pen against the folder in front of him. "We need to prepare for the likelihood of litigation, not a small claim, a federal civil rights case." The chief nodded. "Agreed." Another commander looked over Mercer's personnel file, flipping through pages with growing concern. There were prior complaints, not sustained, but they're documented, and training flagged issues. The chief frowned. Why was he cleared for solo patrol? The supervisors exchanged uncomfortable glances. Everyone knew the answer, but didn't want to verbalize it. Eventually, someone said it. "Staffing shortages. We've been pushing rookies out sooner than we should." That sentence sealed the department's fate more tightly than anything else. Systems create outcomes, and this outcome was predictable, preventable, and now publicly exposed. The third tremor arrived when the State Judicial Council became officially involved. They requested the body cam footage. They requested statements. They requested the department's training records. Judicial bodies do not move impulsively, but when they move with absolute authority. Ward's professional reputation transformed the event from a procedural incident into a matter of statewide concern. A judge had been profiled and unlawfully detained. That is not a department-level issue. That is a government-level issue. The footage, once reviewed by multiple legal authorities, triggered a chain reaction. Civil rights organizations reached out, quietly at first, then more boldly. The Attorney General's office contacted the department with a standard precedent request for documents, a clear sign they were preparing for deeper involvement. The storm had only just begun. And as the storm gained momentum, Mercer's world shrank further. His union representative met with him in a small office, documents spread across a scratched wooden desk. The representative's expression was not sympathetic. It was calculating. Union reps know which cases are defensible and which are not. This one wasn't. "Dylan," the representative began, "we need to talk realistically." Mercer nodded without lifting his head. "You're facing multiple violations, constitutional, departmental, procedural. The footage is very clear. There's no angle of defense we can stretch into something workable." Mercer rubbed his temples. "Am I getting fired?" The representative did not soften the answer. "You should expect that, yes," Mercer exhaled, the sound trembling in his throat. His career, his new career, the one he had barely begun, was now hanging by a thread, and the thread was fraying under the weight of his own decisions. By late afternoon, the department drafted its internal findings. The conclusion was unavoidable. Officer Mercer had engaged in an unlawful detention based on appearance alone. He had escalated a consensual scenario into an aggressive confrontation without legal justification. His statements suggested implicit racial bias. His actions violated department policy, state law, and federal constitutional standards. The fourth tremor, perhaps the largest, hit when the city's legal office reviewed the footage. City attorneys are trained to assess liability with surgical precision, and their judgment was swift. The city was exposed to significant financial and political risk. And because the victim was a judge, that risk multiplied tenfold. Juries respect judges. Courts trust judges. The media amplifies judges. A case like this would not settle quietly, and it would not settle cheap. Meanwhile, Ward remained composed and methodical. He was not seeking personal vengeance. He was pursuing institutional accountability. In interviews, he spoke calmly about the law, not emotion. He described the officer's conduct with professional restraint. He outlined each constitutional violation in clear, structured language. When asked how the department should respond, his voice stayed even. "Correct the failures," he said, starting with this officer and then with whoever allowed him to be on the street unprepared. When the department finally met with the city's legal team that evening, the tone shifted from analysis to inevitability. They all knew what was coming. A lawsuit was not a question, it was a certainty, and not a small one. Ward had the credibility, evidence, public support, and legal expertise to pursue a case that would reach statewide and possibly national attention. By the time the sun set, the department issued an administrative order placing Mercer on unpaid leave pending termination. The internal memo used the language of finality, severe misconduct, constitutional violation, loss of public trust. There was no room for interpretation. That night, Mercer went home with a box of belongings and a weight that made his apartment feel smaller than it had that morning. His father called him, having already heard whispers of the incident. The conversation was strained. His father, a retired blue-collar worker, asked him what happened. Mercer didn't know how to explain the truth. He didn't know how to say that he had ruined everything, not in a burst of chaos, but in a moment of quiet, unthinking bias. The fifth and final tremor came weeks later when the civil lawsuit was officially filed. The complaint was precise, devastating, and unforgiving. It alleged unlawful detention, racial profiling, violation of the Fourth and 14th Amendments, institutional negligence in training and oversight, and emotional distress. It sought financial damages, policy reforms, and mandatory retraining. Once filed, the lawsuit became public record. Media outlets picked it up within hours. Headlines erupted. Judge profiled by rookie officer, body cam footage raises constitutional concerns. Civil rights lawsuit targets department over unlawful detention of state judges. Training failures exposed in high-level detention incident. The department scrambled to manage the fallout. Press conferences, public statements, assurances of reform, everything departments always say when they are caught, but rarely act upon until forced. When settlement negotiations began, the city attorneys knew they could not fight this case in court. They could not win. The evidence was too clear. The judge's credibility was too strong. The officer's actions were too indefensible. The internal failures were too documented. The settlement was enormous. The reforms mandated were sweeping. The case sent shockwaves across the state. And when the ink dried, the department issued a formal apology to Judge Ward. Officer Mercer's termination became permanent. His certification was revoked. He would never serve in law enforcement again. As for Judge Ward, he returned to the bench with the same calmness he carried throughout the ordeal. On his first day back, the attorneys in his courtroom stood when he entered, but this time the respect in the room carried a deeper weight. He did not address the case directly. He did not comment on the settlement. He simply sat, adjusted his glasses, and began the day's proceedings with the same steady voice he had always used. Because for him, the incident was not a personal victory. It was a necessary correction. And for the viewers who watch this story unfold, the lesson remains the same. The law means nothing if those who enforce it do not understand it. The badge grants authority, but authority collapses without judgment, restraint, and discipline. If you watched this story until the end, subscribe. Tell me where you're watching from. And remember, accountability begins with awareness.